Hello, this is Priyanshu Kar. Today, in this particular video, we shall be discussing about the marital rape exception under Section 375, Exception 2 of the Indian Penal Code. December 16, 2012. Nirbhaya. Sounds similar? Yes, you are right. I'm talking about the infamous tragedy of a 23-year-old woman who had been raped. There is no need to elaborate, as it is beyond debate that rape by a stranger is unacceptable. However, is rape by a husband acceptable? This will open a Pandora's box of harsh comments, fiery debates, and attacking chauvinism. In simple terms, it will yield mixed responses. Some will say it is not rape, while others will condemn it and call it rape indeed. In fact, there has been petitions pending before the Delhi High Court seeking the criminalization of marital rape. So let me clarify that rape within the wedlock by the spouse is called marital rape in very simple terms. The legal fraternity considers rape as sex without consent. However, marriage is considered a contract of implied and compulsory sex. This has kept alive the problematic provision of Section 375, Exception 2 of the Indian Penal Code. This section creates an exception to the offense of rape of forced sexual intercourse by a man with his wife if she is of 15 years of age or above. However, the resistance to recognizing marital rape as a criminal offense in itself stems from ostensible necessity to preserve the institution of marriage. However, it is very important that we resist all forms of exploitation, even if it is in the sphere of which is as private as marriage. Now we shall discuss a particular case which is very important to understand this particular issue. In Independent Thought versus Union of India, a division bench of the Supreme Court of India ruled that this exception shall not be applicable to a man guilty of raping his minor wife. Unfortunately, however, the apex court was categorical that the decision would not apply to marital rape of adult women. This means that husband of a major woman can rape her with immunity, and yet he will not be charged under Section 375 for rape. The classification was held to be arbitrary naturally and violative of Article 14. It is difficult to understand how this rationale can be limited to minor girls alone. Why not extend this to adult women too? Does she lose all her rights when she gets married and she's an adult? Is this acceptable even? A woman cannot be deemed to have implicitly consented to sexual intercourse with her husband simply by virtue of marriage. Interestingly, the court in this particular case stated, and I quote, "It must be remembered that those days are long gone when a married woman or a married girl child, not just a married girl child, right, could be treated as subordinate to her husband or at his beck and call or as his property. Constitutionally, a female has equal rights as a male, and no statute should be interpreted or understood to derogate from this position. If there is some theory that propounds such an unconstitutional myth, then the theory deserves to be completely demolished." Unquote. Thus, the basis of the violation of Article 21, as identified by the court itself, is applicable equally and in the same way to adult women who are married as it is to child brides. Moreover, this exception is a violation to Article 14, as was held by the court in this particular case. This rationale should be extended, I argue, to married women who also enjoy the equal fundamental rights as any other citizen in this particular country. I urge that this exception be struck down by the court and the autonomous consent of an empowered equal woman be given opportunity and the priority, so that the sacred values of our constitution are upheld and we achieve the true social democracy as was envisaged by our constitutional makers, including Baba Saheb Ambedkar. Thank you so much. I hope you love this video.